We all make promises to our loved ones. Yeah, I'll help you with the house. Or, don't worry, I'll cover that bill. But what happens when that promise gets broken? Is it just a family argument? Or could it actually be a breach of contract? We're about to dive into that very blurry line.
I mean, it's a wild question, isn't it? The idea of taking your own partner to court, it just seems so extreme. But legally, it's not really about feelings. It's about whether a real enforceable agreement was ever made. And the answer to that is a classic lawyer response. Well, it depends.
And to really get how the law figures this out, we're going to look at the stories of two very different couples. Believe it or not, their cases, decades apart, pretty much set the rules for everyone else.
Okay, so our story starts way back in 1919 with a case that established the fundamental rule for these kinds of agreements. Let's talk about the Balfours. So picture this. The story is pretty straightforward. Mr. Balfour promised to send his wife a monthly payment because she had to stay behind in England for medical reasons. They were married, and at that point, everything was fine. But later on, the relationship fell apart, the payments stopped, and Mrs. Balfour did what she thought was right. She took him to court to get the money he promised. So what did the court say? Well, their decision was crystal clear. They called it a domestic arrangement. Basically, they said that promises made between a husband and wife are usually based on love and affection, not a cold, calculated intention to create a business deal that you can sue over.
And this case gave us a really important legal idea, a legal presumption. Think of it like the law's default setting. When it comes to agreements made within a family, that default is automatically set to no legal intention. The court just assumes that you did not mean for your promises to be legally binding. And because of that legal assumption, that default setting, Mrs. Balfour lost her case. The promise was just a promise, not a contract that a court could force him to keep.
So it seems pretty simple, doesn't it? A promise between spouses isn't a contract. Case closed, right? Well, not so fast. The law is almost never that simple.
What happens when the couple isn't living together happily anymore? What if that love and affection the court was talking about is totally gone? This is where our story takes a really interesting turn.
Let's fast forward about 50 years to 1970 and meet our second couple, the Merritts. See, their case didn't just follow the rule, it showed everybody exactly how to break it. The situation here starts off completely different. Mr. and Mrs. Merritt were already separated. They met up to figure out their finances, and Mr. Merritt actually signed a piece of paper. He promised to transfer the family home into his wife's name once she finished paying off the mortgage. She did her part, paid it all off, but then he refused to sign the house over.
So why was this a whole different ballgame? Well, first, and this is crucial, they were separated. The court pointed out that they were dealing with each other at arm's length, not as a loving couple. And second, they didn't just talk about it, they put it down in writing and signed it. That's a huge deal. And the result? You might have guessed it, the complete opposite of the Balfour case. The court ruled that this absolutely was an enforceable contract. Mr. Merritt had to honor his written promise. This brings us to our second big legal idea, rebutting the presumption. Remember that default setting we talked about? Well, the Merritt situation, the fact they were separated and had a written document, provided enough evidence to flip that switch. They proved that in their specific case, they did intend to create a legally binding deal. All right, so we've got two family promises with two totally different endings. Let's put them side by side because this is where we get to the most important lesson here. Context is everything. When you look at it like this, the contrast is just so clear. On one hand, you have the Balfours. Together, a verbal promise made in trust, and it was not enforceable. On the other hand, the Merritts. Separated, a written agreement hashing out the details, and it was absolutely enforceable. It all boils down to one simple word, intention. The law can't read your mind, right? So instead, it has to look for outside clues, real-world evidence that shows whether you actually meant for your promise to be a serious, legally binding contract. So how does a court figure out that intention? Well, it looks for clues. It asks questions. What's the relationship status? Are you together or separated? What was the setting? Was this just a casual chat over coffee or a more formal discussion? What were the exact words used? Was it a vague promise or were there specific terms? And the really big one, did you put it in writing? Ultimately, that line between a sweet, loving promise and a cold, hard legal contract is all drawn by your intent. So the next time you make a serious promise to a family member, especially if you're writing it down, just ask yourself, what am I really intending here?
Because as these two stories show us, the answer to that question makes all the difference in the world.